Exam Scholar, Real Estate Edition.
Question 1. Which of the following factors primarily affects supply in the real estate market? A. Population. B. Demographics. C. Employment. D. Government financial policies. Answer. D. Population, demographics and employment impact demand for a commodity, but government fiscal, spending and taxing policies strongly influence availability and cost of credit for those who produce things to be sold, like new homes. Question 2. Of the following, the method which allows the most depreciation to be taken during the first year would be A. Straight line method. B. 150% declining balance method. C. 200% declining balance method. D. Sum of the year's digits method. Answer. C. The 200% declining balance method of depreciation allows the most depreciation for the first year. The sum of the year's digits method allows the most depreciation in the earlier years. Question 3. Daniels purchased 60 acres of land near a city. He intended to subdivide it for sale as single-family residential lots and sell the lots for cash. Daniels needs maximum financing to put in streets, curbs, gutters, sidewalks, etc. He wants to pass the cost of these to the lot purchasers in such a way that when title policies are issued to future lot owners, the policies will contain no reference to assessment liens for the above stated purposes. Daniels' best course for financing these needs will probably be A. Real property sales contracts. B. Improvement bonds. C. Interim loans from institutional lenders. D. Corporate stock. Answer. C. Answer B would result in assessment liens. Answers A and D are not specifically financing means for such improvements. By elimination, answer C is the best choice. Question 4. A new well and pump were installed on a parcel of land. For property tax assessment purposes, the county assessor would consider these as A. Improvements. B. Additions. C. Part of the land. D. Personal property. Answer. A. A well and pump would be improvements to the real property. Question 5. Which of the following factors is most likely to influence demand for real estate? A. The number of real estate brokers in the area. B. The number of full-time real estate salespersons in the area. C. The wage levels and employment opportunities. D. The price of new homes being built in the area. Answer. C. When wage levels and job expansion are increasing, workers are more likely to buy real estate. When wages are stagnant or declining, they hold back from making big purchasing commitments. Effective demand requires not only the desire to purchase a product, but also the financial means to do so. Question 6. The one unity in a joint tenancy holding that is also present in tenancy and common holding is A. Equal right of possession. B. Right of survivorship. C. Equal interest of all owners. D. Tenant in possession can be charged rent for the use of the land. Answer. A. Under any type of ownership, each owner has an equal right of possession. This means that any owner can go anywhere on the property regardless of the percentage of their overall interest. Question 7. As a part of the purchase price, the seller of a parcel of land accepted a purchase money first trust deed which contained a subordinate clause. This clause would A. Guarantee priority of the first trust deed. B. Preclude the buyer from placing construction loans on the property. C. B. Permit the buyer to place a future loan on the property that would have priority. D. Permit additional liens to be placed against the property without the buyer's consent. Answer. C. A loan in a trust deed that contains a subordination clause supersedes the rule the first to record is the first in right. A subordination clause in a note and trust deed is evidence that the lender agrees that a future obtained trust deed may be prior to this loan even though the future loan is recorded later. Oftentimes builders use this clause in a trust deed and note used to purchase raw land from the owner. They offer the owner the full price contingent upon him carrying back financing for the land. The trust deed that he is to receive from the builder must contain a subordination clause in which the owner of the land agrees to be junior in priority to a future recorded construction loan. Question 8. Capitalization is an appraisal process used to A. Convert net income into market value. B. Establish book value. C. Determine net income. D. Establish a capitalization rate. Answer. A. Capitalization of income is a method of establishing the value of income-type properties. Question 9. The type of legal action that would most likely be taken in the event of a default on a land contract would be A. Lease pendens. B. Writ of execution. C. Foreclosure by trustee's sale. D. Quiet title action. Answer D. If the original land contract had been recorded and the buyer has defaulted, there would be a cloud on the title and some form of legal action would be required to clear the title. This would not be a foreclosure but a quiet title action. Question 10. A subordination clause in a trust deed may A. Give priority to liens subsequently recorded against the property. B. Allow for periodic renegotiation and adjustment in the terms of the obligation. C. Prohibit the trustor from making an additional loan against the property before the trust deed is paid off. D. Permit the obligation to be paid off ahead of schedule. Answer. A. A subordination clause written into a loan gives a lower, secondary position to that loan if another loan is recorded later. Question 1. Which of the following real estate syndicates requires 100 or more investors? A. Limited partnership. B. Joint venture. C. Corporation. D. Real estate investment trust. Answer. D. A real estate investment trust, which is organized under federal laws, must have 100 or more investors. Question 2. A purchaser of real property utilizing leverage is A. Using the maximum amount of his own money to purchase property. B. Using the maximum amount of borrowed money to purchase property. C. Making the maximum down payment for the property. D. None of the above. Answer. B. Leverage is the use of credit, borrowed money, to purchase a property. When a property is 80% leveraged, it means a debt on the property is 80% of its value. The owner's equity is 20%. Question 3. A licensed contractor purchased 8 lots in a new subdivision and constructed 8 homes on the lots. He sold the 8 homes to various buyers and took back a $5,000 second trust deed on each of them. He would now like to sell the trust deeds within the year of their creation at a 20% discount. In order for him to do this, he A. Needs a real estate license. B. Must sell them through a real property securities dealer. C. Does not need a permit. D. Must deliver a real property security statement. Answer. A. These second trust deeds are classified as promotional notes and are real property securities. The contractor must obtain a permit to sell them, and since he is handling 8 in one calendar year, he is considered to be in the business and must have a license to sell them through a licensee. A dealer's endorsement is not required. Question 4. Which of the following statements is correct concerning a land contract? A. It is used when the seller wishes to convey title without a trustee relationship. B. It is similar to a lease in that the buyer has a right of possession but no rights in the title. C. The buyer has absolute assurance of receiving title upon performance of the contract. D. It is the least secure method of financing real property for the buyer because the seller has retained the title and the buyer is merely the equitable owner. Answer. D. A land contract is a security device used in financing real property, but it is the least secure method for the buyer, since the seller does retain the title. The buyer is the equitable owner, which means that he can use the property. While the seller retains the title, the buyer has rights in that title, and he often records the land contract to give public notice of those rights. Question 5. The liquidity of a borrower is generally determined by a loan officer in considering A. Debt to equity. B. Income total assets. C. Current assets to current liabilities. D. Fixed assets to current assets. Answer. C. A loan officer in determining the liquidity of a borrower is attempting to determine his ability to pay off current bills. Current assets to current liabilities would be the test he would use. Question 6. The owner of a property who signed a listing with a broker for 30 days was killed in an accident before the listing expired. The listing is A. No good as an authorization but binding if a buyer is secured later. B. Still in effect as the owner's interest was clear. C. Binding upon owner's heirs to carry out his promises. D. Terminated by the death of the owner. Answer. D. All personal service contract, such as listings, are terminated immediately upon death of either party. Question 7. Which of the following would usually be considered real property? A. Timber. B. Airspace above the land. C. Unharvested crops already contracted for. D. Land-filled dirt being moved. Answer. B. Of the choices given, airspace above the land is considered real property. Question 8. Conventional loans are distinguished from FHA-insured loans by all of the following except A. Conventional loans provide for a lower loan-to-value ratio. B. FHA loans generally provide for a longer repayment period. C. Conventional loans always permit a deficiency judgment, while FHA loans never allow them. D. Interest rates on FHA loans are generally lower than those on conventional loans. Answer. C. Deficiency judgments are not allowed on purchase. Question 9. Brother and sister purchase property as joint tenants. Later, the sister marries and deeded her interest to herself and her husband. A. The joint tenancy continues to exist in all three persons. B. The brother remains as a joint tenant. C. The joint tenancy is terminated. D. The sister's deed to her husband is voidable by the brother. Answer. C. Joint tenancy require the four equal unities of time, title, interest and possession between two or more parties. Once any of the four unities is broken, it can no longer be a joint tenancy. Question 10. Theft as it relates to real property includes all of the following except A. Entering and removing part of the realty. B. Defrauding by misrepresentation. C. Signing another's name without authorization. D. Carrying away any portion of the security of a mortgage with the intent to defraud the mortgage. Answer. C. Signing another person's name as forgery. It may lead to theft in our way of thinking, but is not defined as such in the Penal Code. Question 1. A buyer of a residence, prior to the close of escrow, asks the broker for permission to move into the property. The broker should A. Deny the buyer permission. B. Grant the buyer oral permission. C. Ask the buyer to sign a lease for the property. D. Obtain written consent from the owner. Answer. D. Prior to the close of escrow, the seller is still the owner, therefore, the broker should get written consent from the owner before allowing a buyer to take possession. Question 2. An alienation clause provides that A. The principal amount of the loan, plus accrued interest, is due in the event of the sale of the property. B. The mortgage is security for a promissory note. C. A lien can be placed on the property that takes precedence over a prior recorded trust deed. D. None of the above. Answer. A. Also called due on sale. It states that the lender may demand the loan plus accrued interest be paid in full in the event the property is sold. Question 3. If a man has a freehold estate, which of the following would result in his having a less than freehold estate? A. Sale and leaseback. B. Selling the mineral rights to a third party. C. Giving a leasehold interest for 5 years. D. Granting a life estate. Answer. A. A less than freehold estate is a landlord/tenant arrangement. Of the choices offered, only a sale leaseback would result in a less than freehold estate. Question 4. Broker Young, as an agent, showed a property to James. James signed a deposit receipt which contained the following words: buyer to accept the property in an as-is condition. Broker Young knew that the plumbing in the property was in a major state of disrepair with parts missing, but he did not tell James. The problem with the plumbing would not be apparent to an ordinary, prudent person. If James sued the seller for damages for fraud, the court suit would probably be A. Unsuccessful because the as-is provision in the deposit receipt shows that there is a mutual understanding of possible defects. B. Unsuccessful because the deposit receipt specifically state buyer to accept the property in an as-is condition. C. Successful because the duty to disclose a material fact cannot be avoided by an as-is provision under the stated circumstances. D. Successful because as-is refers only to obvious defects. Answer. C. The real estate commissioner and the courts are very protective of consumers. Therefore, they will not allow an as-is clause to be valid except for obvious defects, which any reasonable and prudent person could discover. Question 5. To alienate title to real property, one would A. Encumber it. B. Place a homestead on the property. C. Convey the title. D. Cloud the title. Answer. C. The term alienate means to transfer or convey. To alienate title means to convey it. Question 6. Real property would include A. Real property tax lien. B. Trust deed. C. Crude oil which has just reached the surface in a pipe drilled beneath the land. D. None of the above are real property. Answer. D. None of the possible answers to this question is real property. A tax lien and a trust deed, although having to do with real property, are not real property. Oil which has been captured is personal property. Question 7. Which is true concerning an option? A. Title acquired by exercising an option usually dates back to the time of the option and cuts off intervening rights acquiring with knowledge of the existence of the option. B. Only the optioner is bound to a sale. C. The optionee has no interest or estate in the land. D. All of the above statements are true. Answer. D. All of these statements are true. Question 8. Abel buys Blackacre from Baker, taking title to the property subject to the existing loan. The person primarily responsible for the repayment of the loan would be A. Able. B. Baker. C. Either Able or Baker. D. Neither Able or Baker. Answer. B. When a buyer takes title subject to the loan, the seller retains the responsibility for the repayment of the note. The buyer takes no responsibility for the note. The buyer can lose a property by foreclosure because a property was bought encumbered with loan, but after the foreclosure, if there is a deficiency in the process, the buyer is not liable for that note deficiency. Any suit would be against the seller for the deficiency judgment as the buyer's name does not appear on the note. Question 9. A lessee's interest is A. Personal property. B. A chattel reel. C. A grant to use property for a period of time which reverts to the grantor at the expiration of the term. D. All of the above. Answer. D. All three choices refer to the lessee's interest in real property. Always keep in mind that a lessee's interest is personal property known as chattel reel. Question 10. An apartment owner was figuring his net income for income tax purposes. He took the gross income and deducted certain expenses. Of the ones listed below, which could he not deduct? A. Depreciation. B. Interest on loan for purpose of purchasing the property. C. Management expenses. D. Cost of offense. Answer. D. Offense would be a capital improvement. The cost of it should be added to the cost basis of the property and depreciated. Question 1. During broker Shaw's preparation of the exclusive authorization and right to sell on seller Norman's property, Norman asked that a clause be included which would require the buyer to accept primary liability in connection with when the existing loan is transferred to the buyer. Shaw should enter which of the following in paragraph 2 of the exclusive authorization and right to sell? A. Buyer to take the property subject to the loan. B. Buyer to assume existing loan. C. Buyer to pay all cash. D. Buyer to make a large down payment to preclude possibility of a foreclosure. Answer. B. If a buyer assumes an existing loan, he accepts primary liability for that loan. Question 2. A third party who takes a promissory note that is complete and regular and has no knowledge of any defects is known as A. An endorser. B. A maker. C. A payee. D. Holder in due course. Answer. D. The party that accepts the endorsed note from the original payee without knowledge of any defects is known as the holder in due course. Question 3. The owner of a single-family residence plans to sell and wants to obtain an FHA appraisal to permit a sale with FHA financing. He should A. Contact the nearest FHA office for an appraisal of this property. B. Have a lender apply for a firm commitment. C. Have a lender apply for a conditional commitment. D. Submit a recent appraisal of his home to FHA. Answer. C. The recommended process for the lender to contact FHA for a conditional commitment, that is, for advance assurance that an FHA loan will be made, establishing the loan value for the house. Question 4. A buyer defaults in making payments on a loan, therefore the lender's action probably would result in A. Subordination. B. Escalation. C. Acceleration. D. Alienation. Answer. C. Acceleration indicates the right to declare the entire sum of a note to be due and payable immediately. Most trust deeds contain several acceleration clauses. Most common states, if you become delinquent in the payment on this note, the entire sum of the note becomes due and payable immediately. Other states, The entire sum of the note is due upon the sale or transfer of the property triggered by the sale of the property and therefore is a specific acceleration clause. The rule is, alienation clauses are types of acceleration clauses, but not all acceleration clauses are alienation clauses. Question 5. Which of the following is the classic definition of the boundaries of real property? A. A surface area indicated on a map. B. A reasonable use of airspace and extended to the center or the earth. C. A reasonable distance down and unlimited airspace. D. A practical or reasonable use of the earth and unlimited airspace. Answer. B. The surface of the earth and the material beneath the surface to the center of the earth is part of the real property. Since airways are now public domain, the ownership of airspace is used to an enjoyable and reasonable height. Question 6. A buyer defaults on a loan, therefore the lender would be able to cause the promissory note to become due and payable. This clause is A. A subordination clause. B. An escalator clause. C. An acceleration clause. D. An alienation clause. Answer. C. Acceleration clauses are several different types and reasons. Question 7. In general, when the supply of a certain commodity increases. A. Price tends to rise. B. Price tends to drop. C. Demand for it tends to rise. D. Demand for it tends to drop. Answer. B. If demand is constant and supply increases, sellers compete with each other by lowering prices. Question 8. An offer to purchase real property was signed by a prospective buyer on October 2, 1977. The terms of the offer allowed 5 days for acceptance by the seller. Because of an illness in the seller's family, the seller did not accept the offer until October 10, 1977. Which of the following statements is correct? A. The buyer may demand the return of his deposit. B. The buyer must continue with the purchase because he did not withdraw his offer prior to acceptance. C. If the buyer does not complete the purchase, the seller is entitled to the deposit. D. If the buyer does not complete the purchase, the seller and the broker will each be entitled to 1/2 of the deposit. Answer. A. This constitutes only an offer, and one method of terminating an offer is the expiration of a specified or reasonable length of time for the acceptance to be communicated. Question 9. An offer by one of the parties to a real estate transaction to carry out that party's part of the contract is called a. Gratuity. B. Satisfaction. C. Recourse. D. Tender. Answer. D. Usually made at the conclusion of the transaction, the tender is the offer to perform on the terms agreed to. If the other party cannot perform, then the party that made the tender can rightfully claim the other party defaulted. Question 10. Should a person be discriminated against, what would best describe the actions available to them? A. Private action in a state or federal court. B. Civil action in state superior court. C. Criminal action in a state court. D. Criminal action in a federal court. Answer. A. As discrimination is not a criminal act, we would eliminate answers 3 and 4. 2 is incorrect as the remedy available to the injured party is not limited to only action through a state court. It could take place through the federal courts. Question 1. Which of these instruments does not contain the interest rate, loan amount, term of the loan, and monthly payments? A. Mortgage. B. Deed. C. Lease. D. None of these. Answer. D. None of the listed instruments contain the interest rate, loan amount, term of the loan, or monthly payments. The type of instrument that does contain these is the note. Question 2. Anthony receives a tax bill that is related to cost per front foot and amount of benefit he receives. This type of tax bill would be called A. Eagle. B. Special assessment. C. Front foot assessment. D. None of these. Answer. B. Special assessments are generally repayment to the government for installation of curbs, gutters, and other enhancements. The cost of these is based on the amount of benefit that a particular property receives from the enhancements. Question 3. Retaining a property while at the same time using it as collateral to secure a loan is called A. Promissory. B. Hypothecation. C. Accretion. D. Collation. Answer. B. The act of using property to secure a loan while at the same time retaining the use and benefit of the property is called hypothecation. Question 4. In which clause does it allow for a buyer to be free of recourse in the event of foreclosure? A. Ad hominem clause. B. Dispersal clause. C. Exculpatory clause. D. Extradition clause. Answer. C. An exculpatory clause acts as a non-recourse loan. This means the lender can only look to the property for the satisfaction of the loan. The buyer is not personally responsible for the note. Question 5. Referral fees are legal to be paid if they are given to A. Licensed brokers. B. Licensed agents. C. Anyone. D. None of these. Answer. A. Referral fees are legal to be paid only to licensed brokers. Question 6. The secondary mortgage market consists of which major participants? A. Fannie Mae. B. Ginnie Mae. C. FHLMC. D. All of these. Answer. D. Fannie Mae, Ginnie Mae, and FHLMC are all major participants in the secondary mortgage market. Question 7. What does a general warranty deed contain? A. Covenants that warrant the new owners undisturbed and clear title. B. Covenants that include provisions of a quitclaim deed. C. Covenants regarding quiet enjoyment. D. None of these. Answer. A. Covenants that warrant the new owners undisturbed and clear title are contained in a general warranty deed. Question 8. A general agent has full authority to A. Bind the principal to all agreements. B. Act as attorney at law. C. Act in the bounds of power of attorney. D. Only bind principal to agreements with written consent from the principal. Answer. A. A general agent is a representative of a principal that has the full authority to bind the principal to all agreements. Question 9. The income approach to appraisal uses which kind of rate? A. Market. B. Capitalization. C. Index. D. Consumer. Answer. B. The capitalization rate, or cap rate, is used in the income approach to appraisal and is an analysis of how much investors are willing to spend in a certain neighborhood in return for a certain amount of income. Question 10. Which of these is an example of a general agent that has the authority to make binding decisions on behalf of the principal? A. An attorney at law. B. A real estate agent. C. A real estate broker. D. A property manager. Answer D. A property manager is a good example of a general agent who has been empowered to make binding decisions on behalf of the principal.
Exam Scholar, Real Estate Edition.